Welcome to the Supreme Grammar Podcast, where you can learn to write like a Supreme Court Justice, with me, Jill Barton. Today, our AI hosts focus on the R and E of CREAC. Think of these as your setup, where you show what the law is and how it works before applying it to the facts. Then, the rest of your analysis will flow naturally. Let's listen in.
Welcome to the deep dive. Sometimes legal writing can feel like you're trying to solve a puzzle, maybe with some pieces missing. Well, today we're really going to focus on unlocking how to craft arguments that truly land. We're mastering the rule and explanation sections. These are often kind of overlooked, but they're key parts of legal analysis frameworks. We're talking IRAC, that's issue, rule, application, conclusion, and also CREAC, which is conclusion, rule, explanation, application, conclusion. Think of this as like your blueprint. It helps turn dense info into real clarity for judges, employers, everyone.
That's exactly right. It's fascinating, isn't it? So many people can, state the law, but making it live, making it connect, that's different. These sections, the rule and explanation, they're where you really show that you've synthesized the authorities. It's not just knowing, it's understanding deeply. And today, we'll give you those precise tools you need to really make that happen.
Okay, fantastic. So let's unpack that rule section first. We've narrowed down our legal question right. Now, the rules section. It's broad, lays out the controlling law. It gives the reader the whole legal picture. So what are the key principles for writing a really strong rule section?
Well, the core idea fundamentally is organization. You absolutely have to move from the general to the specific, but it's more than just structure. It's about building credibility right away. You grasp the big picture before the details, keeps the reader with you, so you start broad. The most important rule, highest authority. Maybe a constitution, state constitution on free speech, say, or statutes defining key terms like dwelling in a burglary case. What exactly counts as a dwelling? Then you start layering in the specifics, adding those finer points to the main rule.
Right. And this is where I think it gets really interesting understanding that rules themselves come in different types almost.
Exactly. Different flavors, you could say. Your rules section might need to define key legal terms. Things like malice, that specific intent to harm, or maybe gross negligence, that's more than just carelessness, it's a reckless disregard. Or it could lay out a legal test with specific elements. Think of these like check boxes. Every single one has to be ticked, like for intentional infliction of emotional distress. You miss one element, the claim fails.
And then you've got other kinds too, like factors tests.
Yes, factors tests. The sleek craft test for trademark confusion is a good example. Here, not every factor necessarily needs to be met. It's more flexible.
Provides a bit more wiggle room, depending on the specifics.
Exactly. And then there are balancing tests. Federal Rule of Evidence 403 is a classic. You weigh one thing against another. Like, how helpful is this piece of evidence, its probative value, versus the danger of, say, unfair prejudice?
Okay. And finally, we can't forget exceptions, right?
Absolutely crucial. Rules often have exceptions. Think about the Fourth Amendment's warrant requirement. Lots of exceptions there. And one thing, maybe the most critical point, use present tense verbs when stating rules. And cite. Cite correctly. Every single sentence stating a rule needs a citation. Seriously, failing to cite just kills your credibility instantly.
Oh, definitely. That's like rule 0 in legal writing.
Yeah.
Okay, so we've laid the solid foundation with the rule section. Now we get to the part where I think the real legal artistry happens, making sense of it all. The E in CREAC, the explanation section. How do we actually explain what these rules mean for our specific problem?
Right. This is where you translate. You take those rules, those abstract principles, and you explain them in the clearest terms possible for your reader. You're showing how courts have actually interpreted and applied the law in real situations. It's about context, but it's more than just summarizing cases one by one, which raises that key question. How do you truly understand and, importantly, synthesize the authorities for this section?
Synthesis, that's the key word. And that leads us to something you often talk about, anchors. Can you explain that a bit more? What are these anchors? How do we find them? Because like you said, a lot of people just, list case summaries here, but you're saying it's deeper than that.
Precisely. It is much deeper. Anchors aren't just case facts. They're the recurring principles, the specific factual patterns courts consistently look at. They're the why behind the decisions, directly tied to your specific legal question. So take burglary cases about curtilage, that area right around a house. Courts don't just list facts, they look for anchors. Things like, is there an enclosure? Does it have openings? Is the enclosure, fortifying, or is it irregular? These are the anchors. You're pulling these insights out across multiple cases. synthesizing them.
Okay, so you're extracting these core reasoning points. And to do that effectively, you need the big picture, right? Finding that seminal case.
Exactly. Finding a seminal case often helps enormously. It might be the first big case on the issue, or the most recent, or just the most thorough one. You use that and related cases to illustrate your anchors. Think about the landmark Tinker case, student free speech in schools. The key wasn't just the outcome, it was how the Supreme Court set up a framework, the factors they use. That changed how all later cases were analyzed. It gives you a powerful lens.
So not just what the court decided, but how they decided it.
That's it. And often this takes shape using an upside-down triangle structure in your writing. You start broad with a topic sentence about an anchor. Then you get more specific. Facts, holdings, reasoning from relevant cases that illustrate that anchor, and you adjust the detail. Most anchors. Brief case illustrations work fine, 1 or 2 sentences. But if one case, like Tinker, really dominates the issue, you might need a single, more detailed explanation of that case. This whole process shows you've synthesized. It shows how all the pieces, all the authorities fit together for this specific issue.
It really sounds like mastering the rule and explanation sections, whether you're using IRAC or CREAC, goes way beyond passing law school exams. It's about learning to genuinely think deeply about the law, about the authorities. It prepares you for actual legal practice, helps you become that better, more modern writer that, frankly, employers and judges are looking for.
Your rule and explanation sections aren't just a formality. They're where you teach the law. Lay that groundwork well, and your analysis will carry more weight. In our next episode, we'll show you how to write that very important A section of CREAC. Thanks for listening, and remember, you can be a great legal writer.